Hello guys, hello Ma'am Vera, good morning. First, let me introduce myself. My name is Elisabeth Octaviyani Letty. I'm from Corporate Law 4, batch 2024. So, for today, I will explain about a mediation as a method of alternative dispute resolution. Check it out! What is mediation? Mediation is a dispute resolution process where a neutral third party called a mediator helps the disputing parties communicate and negotiate to reach a mutually acceptable agreement. The mediator doesn't have the authority to make decisions like a judge or arbitrator. Instead, the mediator facilitates discussion, identifies the core issues, and helps the parties explore possible solutions. Because of this, the final decision always comes from the parties themselves. Next characteristic of mediation. First, voluntary participation, meaning both parties willing participate in the process. Second, neutrality, where the mediator must remain impartial and not favor any party. Third, confidentiality, meaning that everything discussed during mediation is private and cannot be disclosed outside the process. Mediation works effectively because it focuses on interest rather than legal position. In litigation, parties usually argue about who is legally right or wrong. However, in mediation, the focus shifts to what each party actually needs or wants. A good example of mediation can be seen in business dispute between companies. For instance, imagine a dispute between a supplier and a retail company. The supplier failed to deliver goods on time, which caused financial loss for the retailer. The retailer then demanded compensation. If this dispute goes to court, the judge might only decide whether the supplier must pay damage or not. However, through mediation, the mediator helped both parties discuss their interests. The retailer wants compensation for loss, while the supplier wants to maintain the business relationship. After negotiation, both parties may agree that the supplier will provide partial compensation and guarantee faster delivery in future contracts. This example shows why mediation can be more effective than litigation. In court, the outcome is usually win-lose, where one party wins and the other loses. However, mediation allows both parties to create a win-win solution where their interests are accommodated. Mediation also helps maintain relationship, which is particularly important in commercial disputes. So, that's all. Thank you so much for watching. See you. Bye-bye.